Tonight on Nation to Nation, the Supreme Court ruled there is no duty to consult on federal legislation. The former chief of the Mikisew Cree Nation had hoped for better news.
You get a group of young children to make a decision or right from wrong, and they'd probably make a better decision than what the Supreme Court did.
The Supreme Court of Canada also heard arguments today to decide whether Cindy Gladue's alleged killer will be retried.
Women are dying and being murdered, and we need justice. And I think there's no more important case that we should be talking about.
Advocates say her race often overshadowed her horrific death at trial.
It just seems like there was an indifference by the trial court, and that indifference actually ended up demonstrating systemic racism from our position.
Welcome to Nation to Nation. I'm your host, Todd Lamarand. Her death can only be described as horrific. An Alberta mother of three left in a hotel bathtub to die. Cindy Gladue's alleged killer was a truck driver from Ontario. He claimed he paid for sexual services, and Gladue accidentally died. His acquittal angered many.
This protest in Iqaluit was like the protests happening all over the country.
The way she was treated and the verdict of the case is a symptom of systemic racism that needs to be addressed in our country.
In Winnipeg, a winter storm rolled in as the crowd formed. Some felt the weather was an indication of what they say is the cold-heartedness of the judicial system and the way Canada is treating Indigenous women.
But now it's before the Supreme Court. One big issue is whether someone can consent to being injured during sex. But there's also the issue of how Indigenous women are treated in the justice system. It's something the National Inquiry into Missing and Murdered Indigenous Women and Girls has heard a lot. And joining me now is MMIWG counsel Krista Bigcanoe. Welcome to Nation to Nation.
Thank you for having me.
First off, why does the National Inquiry, maybe it sounds obvious, but why does it have an interest in this case?
Well, I think you're right. It does sound obvious. For the last couple of years, we've been traveling the country, hearing the stories firsthand from survivors and from families who have lost loved ones. Missing and murdered Indigenous women is a crisis in this country. And so the obvious connection is Cindy Gladue is Indigenous, and the outcome of this case matters to us because it's about Canadian law and consent. And before commissioners can make recommendations, they need to ensure they understand how Canadian law is treating Indigenous women as victims or complainants. I think it was Daniel Van Muriel, who I'm sure you know, said this might be one of the biggest cases for Indigenous women. Would you agree with her assessment? I would absolutely agree with her assessment. I mean, I think it's been a long time coming. We've heard of many cases over the years where there seems to be a lack of justice for Indigenous women. And so this case was important because we need to understand and know and actually recognize Indigenous women, value them in society, but also within our justice systems. Now, this case, a bit unusual, but we couldn't stream it live. There was no live web stream of it. So what were the gist of the arguments you made before the justices? Well, the National Inquiry, I mean, we only have 5 minutes, so it's always really quick. And we really want to focus our attention on something called judicial notice. Essentially what judicial notice is, it allows judges to take facts rather than hearing evidence. So when something's so notorious or well known, that the judge doesn't have to hear evidence on it. And our argument was that at the trial level, the judge should have taken judicial notice that Indigenous women are overrepresented as victims, and that Cindy Gladue was the exact kind of victim that the court should have been more careful with. During the proceedings at the trial level, she was referred to many times as Native woman, Native prostitute, and it just seems like there was an indifference by the trial court, and that indifference actually ended up demonstrating systemic racism from our position. Do you think it was symbolized by the fact that a piece of her body was kept and presented to the jury? That is always something that's dumbfounded me. We didn't address it as the National Inquiry in this particular proceeding. I have previously written about it and spoken about it as an Indigenous woman, as any woman. The concept that your private or sacred parts could be held in a courtroom as evidence is, I think, disgusting and also very frustrating. It wasn't dealt with in this particular appeal because that was not one of the issues at stake. And as interveners, we had no right to speak to the merits or the outcome, but focused our attention on specific legal components. One of those being, you know what, if if we can call a national inquiry into missing and murdered Indigenous women, I think it's a pretty notorious fact that it's a crisis and that more care needs to be taken.
Of course, you've heard a lot about from Indigenous women as your job as counsel with the inquiry. I guess what happened to Cindy Gladue, how does it reflect what you've heard so far?
I mean, I am not one of the commissioners, but as commission counsel that has sat in literally hundreds of hearings, a common theme and thread that the National Inquiry has heard is how women feel like they don't have justice served to them, that often they're victims, but they're very rarely listened to when it comes to courts. They feel like they're maligned from the system, they're absolutely estranged, and don't feel like they have a voice. And it seems like, at least on what we've heard from families and survivors, that it's really hard to actually seek and find justice.
What about the issue of consent? It certainly came up in the trial itself. Do you think this is something that the justices will take notice of?
I think it's interesting. There are a number of parties taking different positions. You know, the National Inquiry doesn't believe consent was present. We didn't actually get to make arguments on this again on that limited time. But given her blood alcohol level and a number of other factors, we don't believe, our position is that there was no consent. So it will be interesting. This is what makes this case so big and important, because it has the possibility to change the law of consent as it relates to sexual assault in this country.
Talking about changing consent, can the case also change how the justice system treats women and views them, especially as just sex trade workers?
That's absolutely our hope. The position we went in on explaining the judicial notice, care is required. It is, although our system is about remaining innocent until proven guilty, there has to be a balancing of rights. There has to be a recognition that complainants, and some of them are more vulnerable than others, such as Indigenous women, simply by being Indigenous. And if we don't start making those adjustments in our justice system, we're only going to see the crisis increase, and we're only going to see more victims, and particularly Indigenous female victims.
Do you think this is something that the inquiry can address? I know that really is not in your mandate, I suppose, to really push the police or the justice system, but do you think when you come down to write your final report, maybe even this case might be a big part of it?
I imagine that the case may be mentioned in the final report, and again, I can't speak on behalf of the commissioners who are actually in a position to make findings of fact and to make the recommendations, although I can imagine that they will speak to the circumstances that make Indigenous women vulnerable. And, you know, this is one of those areas where women, Indigenous women, and the stereotypes and assumptions around their availability or accessibility, even when they're not sex workers, is a concern. And so it's something that the justice system, the courts, the police, and other service providers need to be aware of.
Of course, if the Supreme Court does agree with you, we won't know for several months when they render their decision. There'll be a retrial. What if the accused gets found not guilty again? What do you do then?
Well, in that case, if he is acquitted, then you know, hopefully justice will have been served better. Hopefully they wouldn't have let in inadmissible evidence on Cindy's past sexual history or background that would normally require a special hearing or a judge to consider whether or not the evidence was admissible. Hopefully more care and safeguards would be put into place so that she's not referred to as just some Native woman or girl. And hopefully, you know, the jury would have at least been aware, if evidence had gone in, that they were cautioned in a way that understood that it shouldn't be assumed simply because she's Aboriginal or Indigenous that there's a higher likelihood she would consent to the acts that happened to her.
Ms. McCanoe, on that note, I want to thank you for doing this. Thank you for being on Nation to Nation.
Thank you.
Time for a break, but when we come back, a women's coalition weighs in on Gladue. Welcome back. We continue with the death of Cindy Gladue and what the Supreme Court heard earlier today. There were 16 interveners who addressed the court. One of them was the Women's Equality and Liberty Coalition. And we're joined by 3 members of that coalition. I want to welcome to the show Deanne Matt, Mackenzie Jordan, and Hilla Kerna. Welcome to Nation.
Thank you.
First question, I'll start with you, Deanne, is your coalition had intervener status at the Supreme Court, and what was the message you were trying to get across to the justices?
Well, first of all, I think we're all here to make sure that there's justice for Cindy Gladue and her family. And we also wanted to really make sure that the Supreme Court of Canada, the highest court of Canada, sends a clear message and hears first and sends a clear message that violence against women, and especially in this case Indigenous women, has to stop in Canada. The sexist and racist behavior of the court system itself has to change, and everyone is looking at them. I think this case for us is really the ultimate case to really say something about making sure that violence against women is not accepted in our society.
Okay, Ms. Kerner, I just want to pick up something that Ms. Matt was talking about, and talking about race. During the trial, we heard how Cindy Gladue was described as a native prostitute. You know, this came up over and over again, more than 24 times. Could this case begin to address the discrimination against sex trade workers and also Indigenous women in the justice system?
Well, hopefully. Ironically, the fact that Cindy Gladue was so desperate to be prostituting herself, and the fact that she was Indigenous woman, should have been instructive to the judge and to the jury to understand her vulnerability. So instead of discriminating her and acquitting the men who accused of killing her, it should be reinforcing how desperate and vulnerable she is. And we are hoping that the Supreme Court of Canada will pick up on that and will declare prostitution as harmful and exploitive. No woman deserves to be in prostitution. No woman deserves to be so vulnerable and despair to resort to this situation, and definitely not Indigenous women. So we hope the Supreme Court of Canada will send a clear message. It's unacceptable to exploit vulnerable women. It's unacceptable to prey on the vulnerability of Indigenous women.
Ms. Matt, I'll come back to you. For many people, this is a very shocking case, especially the way her body parts were presented in court. Have you ever heard of that happening before?
No. And from what I hear, it has never happened here in Canada, for sure. I don't know about other places around the world, but I think that just shows how, well, first of all, to come back to what you were saying, the fact that she was an Indigenous woman, the fact that she was a prostituted woman, all contributed to look at her as a sub-person, a subhuman. And the court should have, as Hila was saying, should have said this should have been aggravated examples of the acts that he has done. Just as the accused had very hardcore pornography in his laptop, and the court refused to accept it as one of the proof. And it's clear that Ms. Gladue was subjected to his vision of what he wanted to impose on women. And he obviously chose, we think, very purposefully, young Native women, Indigenous women, who was in a dire situation. And for women in that context, it should have been clear that he was responsible for the acts that he committed. He should have been responsible for buying sexual acts, because it is illegal in Canada to buy sexual acts from another human being. And I think it's important to see that we're looking at atrocities that women around the world, and Indigenous women more particularly, face on a day-to-day basis, whether it is being treated as a non-citizen, whether it is treated as a sexual object, someone you can dispose of, someone you can kill. And I think that we have to hear the Supreme Court of Canada saying this got to stop. This has to be the point at which we start really to see changes at the lowest court level.
Ms. Kerner, the court heard the argument also that a person can't provide consent if it leads to bodily harm. Do you think this is something that should happen?
What should happen? Because exactly, I think, as those of us who are familiar with the original trial judgment expose, in this case, like many others who do not get such media attention, how our judges those who appointed to protect women and to hold men accountable completely ignorant on the issue of consent and sexual assault. Of course, an ordinary person can tell from looking at this case, we're talking about a man, white man, physically strong, who had money. We're talking about a native woman, very small body size, intoxicated, who was desperate to money. So the power imbalance is so obvious, the question of consent is muted. But there were other issues that considered to be questionable on consent, and it's obvious that many judges do not understand women's autonomies, bodies' integrity, and that the consent needs to be a voluntary agreement. And if there is a power imbalance, there is no voluntary agreement.
Ms. Jordan, Muriel Stanley Venn, who's the founder of the Institute for the Advancement of Aboriginal Women, has said this is the most important case in her lifetime. Do you agree with that?
I think it's extremely important as an Indigenous woman in Canada, and just my own experience of who I am in the world, and the racism, the discrimination, and especially in the work that I do about men's violence against women. I think it's so important, and right now, like with the inquiry on as well, like women are dying and being murdered, and we need justice. And I think there's no more important case that we should be talking about. We need allies. We need people to stand up and say no more. Like, we really need this court system that says it's here to protect us, and it's not. And I hope that tomorrow that the Supreme Court will listen to us, and they'll hear our voices finally. And if I can use my voice and represent Cindy and get some justice for her, now is the time. There's no more waiting. It has to be now.
Okay, Ms. Jordan, thank you for that. And we're out of time, and of course it'll be many months before we hear the actual decision on this. But thank you all for doing this today.
Thank you.
When we come back, huge disappointment with the Supreme Court of Canada judgment. Welcome back. The Supreme Court ruled on a case today that could have been a game changer. The federal government had a duty to consult on legislation affecting a Cree First Nation in Alberta. The Mukasu had argued that cabinet ministers should have consulted them on a budget bill in 2012, in particular on changes to how bands voted and approved land modifications. This bill actually helped spark the Idle No More movement. But in a 7-2 decision, the court said cabinet ministers do not have to consult. Joining me now is former Chief Stephen Couture from Edmonton. Welcome to Nation to Nation.
Good afternoon.
I know you must be disappointed, but how surprised were you in the decision today?
I was, I'd say, blown away. I was very, very disappointed. I think you get a group of young children to make a decision or right from wrong, and they'd probably make a better decision than what the Supreme Court did.
Why did you choose this legal avenue in the first place?
Well, hoping that, with our case that we won in 2005, that we're able to, be able to just move through this without any challenges or appeals. It really surprised me when the appeal came based on no need to consult while developing legislation, which is a bunch of crock. I feel personally with what the Supreme Court judges is that they don't have the balls to make the right decision in favor of the nations, regardless how my expression, pardon my French, but it's exactly how I feel today.
If you had won the decision today, how would that have affected your relationship between yourself and other First Nations and the federal government?
That would have been very encouraging moving forward. Working in partnership with the federal government, provincial governments, to have better opportunities working together and a better future protecting the environment, and having a say in what goes on within the country. And through our treaty rights, we thought we had that, but it's not being recognized, and it's very disappointing that the case was overturned. Our appeal was overturned.
Now, was this legislation just on how it would affect you and the environment, or, for example, the new cannabis law, which goes into effect next week, would that have been something you felt there would have been a duty to consult you on?
Anything that would impact our inherent and treaty rights, they would have to consult, regardless of what the position that the federal government takes or provincial government takes. They have to consult. Anything that they do within our traditional territories, not within the boundaries of our reserve lands, is within our territories. So our territories overlap right across this country. That includes the 634 nations that have existed over the years, and now it's really put a damper on this relationship. And I don't know what kind of damage controls are going to happen. I doubt there's anything going to happen because of the mistrust now from today. I'm sure it created a big uproar across this country.
But would something as broad as the cannabis law, would that have been something you felt should have been consulted on?
I would think so, because it would have to do with the health and well-being of our people, and rightfully we need to know what the effects are going to be, and it's going to be within our territories that they're going to be growing this marijuana, and how is it going to be managed, and what kind of legislation is going to be in place to govern this. And so it is important that they do things right the first step going forward with any legislation.
Now you kind of answered this. You said there'd probably be an uproar, but what can you and other First Nations do now that this has been overturned, this appeal?
Well, like I said earlier, thank you, Canada. You just gave us the power to really come together and join our forces together and really come together as one nation across this country. The women are going to be involved. They're going to step up with us. You're going to hear a very powerful voice coming from the nations, and you give us that avenue to do so. So thank you for that, Canada.
Okay, former chief, we'll have to leave it at that. Once again, thank you for speaking.
Can I just say something else?
We're all out of time.
Just one second.
Sorry.
I just want to say that I agree with Romeo Saganaz with what he said to Prime Minister Justin Trudeau and his Liberal government, that he does not give a fuck about our Indigenous rights. Thank you.
Okay, on that, thank you again. If you missed any part of tonight's show, you can go check out our podcast. Go to aptnnews.ca/podcast. I'm Paul Lamourant. Thanks for watching.